Thank you, Senator. Senator Blackburn.
Thank you, Mr. Chairman, and to each of you, congratulations. I love hearing your stories, and Ms. Belkengren, it's your mother that had a birthday yesterday?
Yes, her 70th birthday.
Well, happy birthday. The 70s are not a bad decade. Enjoy. And Mr. Kirsch, I would hate to have your check at lunch. I think, sounds like you've got about 50 people to go buy lunch for, and I thought, good gracious, that's going to be quite a bill. So I'm delighted that they are here. But your stories are inspiring, and your backgrounds. It is so interesting to hear your backgrounds and a little bit about you, and I appreciate that you take the time to kind of lay that out for us. Ms. Merchant, let me ask you this. You've never been a judge.
I have not.
And I just wanted to ask you, when I had looked at your background, it appears that most of it is agencies and agency work. Talk to me a little bit about what you will take to the bench with you that would inform your work. What experience is it? How are you going to kind of make that jump, since you've not been a county judge or a state judge, or you just don't have that experience? So lay that out.
Thank you for the question, Senator. I have served as an assistant attorney general, or chief deputy
Right,
assistant
yes.
attorney general, and I've also served as an assistant United States attorney. I've had over 20 years of federal litigation experience.
But no
and
private sector
I have,
experience, right?
During law school, I did clerk for law firms, both large and small, and boutique law firms. I clerked at Phelps Dunbar in Louisiana for 2 summers. I also clerked for a small boutique law firm.
Okay.
And I also served as
But
counsel.
you've done no corporate.
And also with ARCO, with Atlantic Richfield,
Okay.
I was also there for a stint.
Thank you for that. I did not see that part in that was not in your bio. The government-related experience was. So I wanted to see where you were. I know that Senator Kennedy asked you about original public meaning and your understanding of that, and those are important to us. And are you submitting in writing a response to that to him? If not, I'd like it submitted to me in writing.
I'm happy to do that. Thank you, Senator.
That sounds great. Chairman, congratulations to each of you and to your families. We're delighted that y'all are here with us today. Mr. Papillon, I want to come to you and go back to this case with Pastor Spell. That is a thing that concerns me because at the time, Governor Edwards thanked the protesters. So it was okay for protesters to assemble in Louisiana, but not okay for people of faith to assemble. So that is, in my opinion, and I would think to you, that would have been the unconstitutional part of this approach of going against Pastor Spell and ruling against Pastor Spell. So what I'd like to hear from you is why you would see this as not being that restriction on free speech. Why did you think that was acceptable, and what was the legal basis that you went to for that decision?
Thank you, Senator. I'm not familiar with the part about the protesters, but I'm very familiar with the Spell case.
It's a quote that I have in front of me. He thanked the protesters at the time and stated that they were appropriately expressing their concerns and exercising their First Amendment rights.
All right. Again, it's just something my role was in the Spell prosecution, but let me explain that, if I may. It is that in the very early stages of the pandemic, states were faced with the very difficult collision of the very important right to religious expression and the state's power to protect the public. And the law clearly protects religious liberty, but it also gave the state the power that it did. And we later got guidance from the United States Supreme Court in some very important cases. And I believe that had those cases been decided earlier, the order that the governor wrote, which I didn't write, would likely have been written differently. And I didn't choose to prosecute the pastor, but as a lawyer, I represented my client, the state of Louisiana. If I were to be confirmed as a United States district judge, I would very scrupulously follow the First Amendment and the tests that our Supreme Court and the U.S. Fifth Circuit have made very clear that when a secular institution is treated more favorably than religion, strict scrutiny applies, and the state needs to show that whatever remedy it wants to apply is narrowly tailored to achieve the result. And we can't assume the worst, as the courts have said, when people go to church, and the best when they go someplace else like work or the mall. And that is today, I think, a very clear principle of law that I would follow as a judge.
Okay, well, I will tell you that's the thing that really concerns me, is the way that I appreciate your explanation, but the free exercise of religion is very important to Tennesseans. It's important to the religious organizations that call Nashville, Tennessee home. And I'm sure you're aware that there are many. And to have a case where it seems there is a subjective opinion that allows one type place of gathering, allows another type place of gathering, but disadvantages and disallows the exercise of religion, that causes tremendous concern. It seems like an inconsistency of the approach. And as I've reviewed your record, have been concerned about that. My time has just about expired. Mr. Herson, I'm going to come to you and Mr. Daniels with a written question pertaining to your judicial philosophy and your approach on some issues. I was concerned, Mr. Herson, of the remarks you made to Senator Graham on fentanyl and the awareness of fentanyl and the impact that has on our community. Thank you, Mr. Chairman.
Thank
Mr. Chairman.
you, Senator Rono. And now, Senator Blackburn.
Thank you, Mr. Chairman, and congratulations to each of you on your nomination. Judge Alicorn, I want to come to you. Some remarks you made when you were Solicitor General in D.C. to the American Constitution Society event. And you said, and I'm going to quote you through this, that it was in your job you try to carry out and live some of the values of ACS. And here's a portion of the mission statement for ACS, and this is off of their website. It states that ACS mission includes redressing the founding failures of our Constitution and enduring inequities in our laws in pursuit of realized equality. So, in your role as both an advocate and now as a judge, do you subscribe to that part of the mission statement, and what do you see as the enduring inequities in the laws that need to be redressed?
Senator, when I said as Solicitor General that I carry out the values of ACS, it was the values of mentorship and discussion and vibrant discussion and debate.
So then you don't agree with what is on their website? So here's another part for you. It also notes on their website that its goal is to promote laws and policies that advance realized equality. So what laws and policy are you trying to promote? And then is this part of what you're trying to carry out? Is it activism as a judge that you're seeking? So as a federal judge, what would that look like if you're trying to live this out, if you're trying to carry it out, if you're trying to change those laws?
Senator, as a judge, it is not the role to change laws. It is to interpret and apply the laws that this body passes.
Well, in your comments, that's what you said. I'm quoting you, back to you. So how would you advance realized equality from the bench?
Senator, in my current role, I take the law and I apply it to the facts and cases before me. That is what I would do if I were fortunate enough to be confirmed.
Okay, so how would you fulfill your duty to neutrally apply the law of people that are coming before you? So describe to me your method of statutory or constitutional interpretation. How would you carry that out?
Absolutely, Senator. When I am confronted with a statutory or constitutional interpretation case, I take my cues from the Supreme Court. The Supreme Court has instructed in statutory interpretation cases, you first must look at the text, and if the text is unambiguous...
Okay, so what is your understanding of original public meaning?
My understanding of original public meaning is that it is a tool of constitutional interpretation that the Supreme Court has used in interpreting the Second Amendment and the Confrontation Clause, and I would faithfully apply the Supreme Court's mechanisms for interpreting.
Original public meaning seeks an understanding of the statute as it would have been understood by the general public at the time of passage. Okay, let me move on with you for something else. Your previous nominations process, you answered several questions for the record indicating your views on when nationwide injunctions are appropriate. So can you point to any provision of the Constitution or federal law that expressly permits a single district judge to grant relief that is binding on the entire nation? Give me one.
The All Writs Act and Rule 65 and judicial precedents do not foreclose a district judge from entering relief that is beyond the geographical boundaries, but it should be, and as an all injunctive relief, sparingly used because it's a drastic remedy.
But it is appropriate that neither the Constitution nor any federal statute explicitly authorizes district judges to issue nationwide injunctions. Isn't that correct?
It is an equitable remedy that has not been foreclosed.
Isn't that correct? Yes or no?
It is correct that there is no law one way or
That
another.
is accurate. That is correct. Thank you. I appreciate the time.
Senator Hawley?
Thank you, Mr. Chairman, and congratulations to each of you on your nominations, and thank you for being here today. And I know we're going to have some questions that'll come to you as QFRs, so we would ask that you address those. Judge Hall, I want to come to you. I think this work with David Weiss is something that you've heard us go back to. Senator Graham asked you about that, and you said you had no information, participated in no way in that investigation. Is that accurate?
That is accurate, Senator.
Okay. Let me ask you this. Did you have any knowledge of or any communication with the two IRS whistleblowers, Gary Shapley and Joseph Ziegler?
Senator, when I read about that whistleblowing in the news, I had no recollection of ever having met either individual.
Okay, would you like to check your records and be sure you had no communication with them? And we'll put that in a QFR for you to give you the opportunity to double
Certainly,
check
Senator.
those records. Thank you very much. Judge Mahalchik, if I may come to you. We've had some discussion about the Spanier case, and I want to return to that because we're quite sensitive to this issue. In this committee, the president nominated Michael Delaney for a position, Mr. Delaney ended up withdrawing his nomination. And it all came down to his hardball tactics with a young woman. And this was in a sexual assault case. So it is, first of all, perplexing that we have another nominee before us who has a questionable ruling in a case, which we have in your ruling, and dealing with the role of Mr. Spanier's conviction of endangering the welfare of a child during his role as president of Penn State. So this comes across as lack of respect for children and the rule of law, and Senator Kennedy laid out very well how the court came back to you, and the Third Circuit actually said and wrote, and I'm quoting again, that you did not examine this case closely. And therefore, talk for about 30 seconds. If you don't examine cases closely, and if you have a record, a high rate of reversals, then how do we expect you, as you move to the court, to be more careful in your job and more careful in your decision making?
Senator, my rate of reversal in considering the body of my work over the last 10 years, including all civil and criminal decisions, is less than 2%. Most of the decisions reference...
Let me, you're not answering my question. All right, let's put it like this. How do we know you're going to be able to fulfill your duties as a judge? When we look at this, and the Third Circuit has written that you did not examine this case closely. This was a pretty high-profile case, and they called you down about that, and they reversed you in your decision. So how do we know you'll do your job? And how do we know what your method of statutorial interpretation is with the record that you've had?
Senator, the bulk of my record over the last 10 years reflects cases that have been either not appealed or sought reconsideration of by the parties before me, and I think that evidences a trust by the bar and the public in my work. The bulk of my work that has been appealed has been affirmed by the district court and by the Third Circuit, and I think that exhibits a basis for having faith in my work when there has been a reversal.
Okay, let me ask you this. Do you think you were right or wrong in the Spanier case?
Senator, the Third Circuit said that
No, that's not what I'm asking. I said, were you right or were you wrong?
Senator,
what led you to make that decision?
When I approached that case like I approach any case before me, I carefully read the parties' briefs. I had open and engaging argument with the parties.
Do you think you were right or wrong?
When I issued that decision, I thought I was doing it correctly. The Third Circuit found that I did it incorrectly, and I read that decision.
After they reversed you, did you agree with their reversal?
Yes, I would stand by what the Third Circuit has
Thank
said.
you, Mr. Chairman.
I'm sorry.
I think it's Senator Blackburn.
Senator Blackburn's next.
Thank you, Mr. Chairman. Congratulations to each of you. I know that you are excited about what the future holds for you and for your families. Mr. Edwards, one quick question for you. I had looked through your background, and it appears you have a lot of experience in civil matters, but district courts have many criminal cases, and I could only find one criminal case, just one, where you had been counsel in a criminal case. So build this out for me. You have no experience, basically, on the criminal side. So how would you function in that position as a district judge?
Thank you, Senator. Over the course of my career, I have handled several criminal matters, but you're correct that only one as counsel in federal court. But in my role as First Assistant U.S. Attorney, I have oversight over the criminal division in our office, as well as the appellate division in our office. And over the last 15 or so months in that position, I have been involved with the entire criminal process and have learned.
So you're confident in your ability
yes,
to
Senator.
move forward handling
Absolutely.
criminal
Yes.
cases?
Yes,
Okay.
thank you.
Mr. Long, let me come.
Senator.
Thanks, Mr. Chairman.
Senator Blackburn.
Thank you, Mr. Chairman. Mr. Chairman, pertaining to Mr. Ephraim from the previous hearing and panel, and we discussed the Smith case, I went back upstairs and pulled the sentencing memo. I've highlighted where the sentencing guidelines recommended a sentence of life imprisonment. I'd like to submit that for the record and clear the air on that issue.
Without objection.
Thank you. Mr. Fonzone, I do want to come to you. Your position, if you're confirmed, would hold you responsible for reviewing all executive orders, providing legal guidance to each agency in the executive branch, and working closely with A.G. Garland, correct?
That's correct.
Okay, let's talk about this in light of the work you've done for the Chinese Communist Party and for Huawei. Because as Senator Graham said, we're going through a process of ripping and replacing Huawei equipment here in the U.S. And I'd like to know if you regret your work for Huawei, if you regret your work for the Chinese Communist Party, and if you regret advocating for the Chinese Ministry of Commerce, their MOFCOM, which in essence you would have been turning your back on American workers. Do you hold those actions in regret?
Senator, thank you for the question. As I said in response to the earlier question, I did a small amount of work at the request of my partners a long time ago. It hasn't affected my ability to, in my current role, to serve in my current role and provide objective legal advice as the General Counsel of the Office Director of National Intelligence. It would not affect my ability to serve at OLC. A lot of time has passed since I served on a moot court for a partner of mine who was arguing a case for the Ministry of Commerce.
Okay, my time is limited,
Okay.
but you doubled down on this. You did more than just a little bit. And I think one of the things that concerns me is basically your work with the Chinese Ministry of Commerce. You were advising them on how to game the system, the American system, and that causes me concern. Let me ask you this, because you're going to be working with A.G. Garland, and there's been a lot of conversation from Tennesseans that I represent. They're very concerned about 2 tiers of justice and how this affects their lives. So I think it's important that you have the opportunity to assure the American people that you are not going to participate in 2 tiers of justice. And I'd like for you to weigh in for just about 30 seconds. Do you condemn the politicization of the Department of Justice and the actions that have taken place there against parents, against pro-lifers?
Senator, OLC is not a policymaking office. If I'm fortunate enough to be confirmed, OLC's role is a reactive one. It answers legal questions presented to it by other parts of the executive branch. And if confirmed...
Do you condemn the politicization of the department?
Senator, my role at OLC would simply be to provide frank and independent legal advice.
So, okay. All right, so you're not going to do that. Okay, Mr. Keel, let me come to you. I think your mom deserves Mother of the Decade. And I'm delighted that she's here. Senator Hawley came to you on a question about ALDEF and some of their lack of ability to condemn Hamas. So I want to simplify this and see if we can get a response to you, because see, I think your approach and what you believe about things is important. It's important to Tennesseans. This is a life appointment. So knowing how people approach problem solving and approach issues is vitally important. And your answers were really quite troubling to me because it was a non-answer. And we would like something. So do you think that ALDEF needs to release a statement strongly condemning the actions of Hamas, this beheading of babies, this raping of women, this putting babies in an oven? Yes or no? Should they release a statement? Yes or no?
Senator, I don't know anything about the statement.
Okay, let's see. So you have not watched the news lately. Let's move on. Do you believe that Hamas is solely to blame for this unconscionable violence in Israel?
Senator, I tried to respond to Senator Hawley.
So that was a yes or no. So you don't have, see, this is what is of concern to me. Let's go at it this way. So do you believe this is a both sides issue? In other words, do you believe that both Hamas and Israel are to blame on this? Yes or no?
Senator, I don't believe it's a yes or no answer for me. It's a very complicated issue. It's a very tragic situation.
I think that the U.S. recognizes Hamas as a terrorist organization. This ought not to be complicated. I yield.
understand
Thank you,
that,
Mr.
Senator.
Chair.
Judge Keel, do you want to finish your answer?
I did, Senator. Yes, I understand that Hamas is considered a terrorist organization by the United States government.
Thank you. Senator Hirono?
Thank you, Mr. Chairman.